Good morning. Welcome to the Legal 500 and LDIB Advocate webinar called Egypt, Treading Uncharted Waters, Crisis and Planning. We will be hearing shortly from Mohammed Abdelrahim and Richard Tibishari. Nada, could you help me?
Richard Tibishrani.
Thank you very much, Richard Tibishrani. We practiced it and practiced it, and I still get it wrong. From LDIB Advocates later, but first let me introduce, please, Nada El-Dib, who is Business Development and Executive Handler at the firm. So Nada, I believe, has been with the firm for 9 years now.
Correct.
Spends a lot of her time in the port of Alexandria. I guess we'll be covering some of the maritime aspects of.
Yes, I will.
She has Masters in Business and Maritime Law and is the director, I believe, of Matisal. Again, did you answer?
Matisal, yes.
Matisal,
yes.
Which you can perhaps explain briefly what.
So yeah, Matisal is a legal mobile application, and basically we're currently catering to Egypt, hopefully to further expand into the GCC, and our users have access to legal consultation. So they send in their questions, and within 24 hours we get back to them. We also offer them articles regarding legal matters, as well as now we're going to be selling templates on our web platform for users to purchase.
Excellent, great. Well, I'll leave you to crack on with the presentation now, Nada.
Thank you. Good morning, everyone. كل سنة وانتم طيبين. And I just want to give you a little brief on our firm, LDIB Advocates, and then we'll go right straight to the topics we have on our agenda today. So LDIB Advocates is a law firm based in Egypt, and we're happy to announce this year, actually, the firm turned 145 years. We have 4 offices covering Cairo, Alexandria, Port Said, and Suez. We also have a Libya desk and a Sudan desk, which are run out of our Alexandria and Cairo offices. We have a strong team of about 30 lawyers and legal assistants who speak 7 languages, and we cover 10 fields of law, everything ranging from the intricacies of business law, corporate, commercial, IP, arbitration. And today, really, we want to touch on all the things, as the title says, uncharted waters. COVID is something that none of us expected. And yes, there have been things like the Spanish flu, but not in our generation. So we have seen that it has been an extreme effect, not only on Egypt, but worldwide. Egypt recently had experienced an issue with when we had the revolution, but it was quite isolated. So our market was just hit, where now the pandemic is a global issue. And so it's more of a ripple effect. And we're going to see today how we can actually maneuver these changes and hopefully plan for the future. A little bit of a statistic from Ernst & Young. There was, because of COVID-19, they pushed the full year gross domestic product globally down to 2.5%, which was actually forecasted to be 0 in January. And basically the spillover of COVID is going to continue. So workplaces have to really start mitigating these losses through the reduction of staff, and to see how they're going to be able to deal with all their delays in investment and their delays in the distribution of their supply chains. So right off the bat, we just want to get everyone on and active. And if you guys put up the poll we have for people to answer.
Is this with the poll, please, Ben? Sorry, just while we're waiting, a comment to Iman Selam, who says, guys, he can't hear us. Iman, it's your speakers. So I've checked, we are coming through to other people. It's the speakers on your computer need to be turned up. Although if you can't hear me, you won't hear that.
Should we type that in?
Yes. Iman.
So if we can just, we want to get everyone engaged in the first poll. So it's a question: do you feel like your company or your institution has been handling the current global COVID-19 crisis in the best way possible? Yes, no. If you don't care to comment, we also understand. We just want to get a feel of how everyone's feeling right now before we can start going into all the different topics we have for today. So let's run the poll.
And just to say, you need to hit submit. There's submit underneath.
Yeah.
I guess we'll give this a couple of minutes before we cut to the result. What are you expecting to see? It's a pretty leading. Has your organisation been handling the crisis in the best way possible? Yeah.
If I could talk about our firm really tried to do take all the measures necessary with social distancing, working from home, but also we were dealing with courts being closed down, so it was easier to have that. But we feel like also everything is a bit more laid back here. So if we just keep with the proper precautions, but like the WHO has put in place with regards to health regulations and the social distancing, we could maintain a healthy environment. And we're not such a large team in a congested area, but I hope others are taking the necessary precautions.
Has that been difficult? I mean, has it affected the you do business or service client? Not you now, and it's not disrupted.
I'm sorry, it's cutting up. Can you please say that again?
Sorry, yeah. Has putting in place that plan to deal with COVID, has that disrupted your activities, the way you service? Or not?
The only issue that we're really facing with this is the fact that Muhammad's going to touch up on this in that upcoming section exactly, is that the fact that a lot of governmental entities are not fully functioning or are shut down, like the courts, for instance, which are due to come back in June, that has just delayed a lot of our clients' business. It hasn't delayed all our commercial work, or it hasn't delayed all the contracts that we're working on, but anything that are in the courts are definitely being delayed.
Excellent. Well, we're going to cut to the results of the poll now. So
yeah.
What do we have here?
Oh, that's really good.
Surprising. For 50% of people think that their organizations are handling it in the best way possible.
To be honest, that's a better number than I expected, and I'm very happy to see that. Really happy to see that. So now that we can see that people are taking the right precautions, I'm assuming that that also has to do with the regulations that the government has put in place. So I'm just going to introduce our next panelist, who will take us through those points with regards to the effects of COVID, and that is Muhammad Abdurrahim, who's a junior partner at the firm, and he's been with us for over 13 years. So Muhammad will just guide us through the actions taken, which I'm assuming most of these companies are following right now.
Mm-hmm. Right.
So we can add on Muhammad.
Here he is. Mohammed, are you with us?
You're going to have to deal a lot with bad connections in Egypt, so I apologize ahead of time.
He
should be. Yeah, we're good. Okay, I apologize for that. I'm sorry. So thank you, ladies and gentlemen, for joining us today in our legal discussion. Good morning in this sunny and warm day. It is an honor to have you with us today in this beautiful legal discussion. I will be more than happy to answer all of the questions that you have. I'd be more than happy to have as much as engagement as possible from you guys. This is not meant to be a lecture. This is meant to be more or less like a legal discussion between us. Whatever the inquiry you have, just forward it, and we will try as much as possible to answer it, as well as answering the questions that we had before. So moving forward to the topic that we have today, COVID-19 and how it changed the way everything works. From an Egyptian perspective, when one thinks about what did Egypt do to overcome the current crisis, usually the first thing that comes to mind is the curfew that Egypt adopted back in March 24th. However, I would like to state that the Egyptian government actually took a lot of previous measures, a lot of decisions that actually helped in preventing the spread of coronavirus. So, for example, and I don't want to start listing all the decrees that was issued by the Egyptian government. However, few of them are very important to mention, like the Minister Decree number 606 for the year 2020, which prevented all activities that include gatherings of individuals. So this included a lot of things like wedding ceremonies, funeral ceremonies, and a lot of other activities that contains a lot of people or a lot of individuals engaged in it. We have also decision number 717, which suspended all the educational services and the entertainment services in Egypt. We have decision number 718, which suspended the services of airports. We have 724, which prevented cinemas, and so on, so on. As I told you, I don't want to start listing all the decision. However, on March 24th, we had a ministerial decree issued number 768 for the year 2020, which actually applied the curfew here in Egypt for the first time because of the current situation. The ministerial decree included several articles, and each one of them was targeting a special industry or a special field. So, like we all know, there's no movement from 7 p.m. till 6 a.m., no transportation, no malls, no shops, no coffee shops. However, the only exceptions that was given to this ministerial decree was given to grocery stores, bakeries, pharmacies, supermarkets, hospital, and the media production. Also, we have seen the government taking a very severe decision in the ministerial decree number 768 for the year 2020, which is suspending all the services provided by the government. This would include the GAFI, the notary office, all the services that are provided by the government. However, from a legal perspective, I would say that the two entities that would be interesting from a legal perspective more is the courts and the GAFI. So, as you all know, GAFI is an abbreviation for General Authority for Free Zone and Investment, and it's the governmental authority responsible for holding the records of all and incorporating all companies established and operating in the Egyptian territory. So, as per the decision that we referred to earlier, GAFI suspended all its services. We have seen, or at least I have seen the GAFI suspending its services for the first time due to this virus. And then after a while, we had a partial opening of the GAFI, on which you have to make an online application before visiting the GAFI to show exactly or to state exactly why do you want to visit the GAFI. Is it essential to visit the GAFI at this moment? And then they will provide you with the date and the time when exactly you should you should be allowed to enter the GAFI to finish your businesses. To be honest with you, and from a personal perspective, I love how this worked one way or another. I didn't see this coming, this sort of organization or this sort of order. I didn't see this coming. So I love how the GAFI managed the crisis now. Another decision that was also adopted in March 2020 that actually facilitated a lot of things and a lot of procedure rather than being stuck with the lockdown in countries abroad or the partial closures that we are having here in Egypt is that the GAFI allowed for the companies, whether LLC or joint stock companies, to hold their board of director meeting if we're talking about joint stock company, or the OGM and the EGM if we're talking about LLC and the OGM, to conclude these meetings in video conference, even though the Articles of Association does not stipulate on the ability to have these meetings in video conference. So you have your meeting in video conference, you get a recording of it, you go to the GAFI, you submit all the documents originally signed after being circulated between all the attendees. You go to the GAFI, you submit it, and everything goes well. So this is something that actually facilitated the operation of the companies, that facilitated the business, guaranteed that we don't suffer any stoppage in the operation of any of our clients, and everything is going smoothly. On the other hand, we refer to the second legal entity that would be more of interest to us is the courts. So we had the courts, as per the decision that was issued in March 24th, we had the courts suspending all the services to the public. All the districts were closed, save for the ones related to criminal cases. And we have also seen the public prosecutors working only maybe 20 to 25 capacity. There are no night shifts. And in the mornings, it's not that as it used to be before the virus. I know we're going to cover the topic at the end of our discussion today, but we have seen digitalization of the legal services here provided by the government. We have seen, for example, back in August 2019, the Economic Court had a new law that actually allows for filing a claim electronically, that actually allowed for notifying the parties electronically. There is no, we're still pending on how this will be implemented, on how this will be executed, but at least we can say confidently that this is a huge step to apply it here in Egypt. I'm sorry. And if we are going to apply this on the Economic Court, I can imagine within a couple of years, maybe this will be applied to the other courts. I believe mentioning courts would also necessitate mentioning the arbitration and how the arbitration was actually affected by the current situation. So arbitration, actually, I would say that it did not get affected or even got affected like 5 or 10%, because from a personal perspective, from a personal experience, usually I work with Cairo Regional Center for International Commercial Arbitration, and this is one of the best venues here in Egypt to have your institutional arbitration. And I would like to discuss with you the two articles that actually allowed CIRSICA to operate without being affected by the current situation. So please, James, if we can pull up the first slide in arbitration.
Well, we're about to look now. Just remind everyone listening in, please do submit your questions as the presentation is on. So we're happy to answer any questions you may have. If Mohammed or Nada or Richard say anything you're unsure about, please ask a question in the box below. You can see Omar is typing now. Mohammed, back to you.
Okay, so as we can see at the moment is Article 17.1 of CIRSICA's rules. I know it's a bit boring to read an article for you, but let me just grab one sentence out of it. So according to this rule, subject to these rules, the arbitral tribunal may conduct the arbitration in such a manner as it considers appropriate, provided that the parties are treated with equality and that an appropriate stage of the procedure is each party is given an equal and full opportunity of presenting his case. So basically what this article says is that the arbitral tribunal has the full and absolute power to handle the arbitral claim in any manner they want. So actually you don't have to meet to for the procedure hearing. You don't have to meet for the oral hearing. So basically, the arbitral tribunal has the authority to do whatever they want as long as they guarantee that both parties are treated equally and that each party has or had the proper opportunity to present his case. The second slide we have here is Article 17.3. I would only read the last paragraph of it, the last sentence. The arbitral tribunal shall decide whether to hold such hearing or whether the procedures shall be conducted on the basis of documents and other materials. So this article is actually referring to the oral hearing that you have by the end of the arbitral procedures. And this article gives the right to the arbitral tribunal to conduct or not to conduct this hearing based on their understanding of the claim, based on the needs of the claim, and based if they see that this claim actually needs to have an oral hearing or just the documents that have been submitted already are efficient.
So, Mohammed, I was wondering, because I know that you're currently dealing with certain cases, can you just give us your current experience with doing arbitration remotely? How has that been, and what's the current process you're going through?
Okay. As you know, we're under a client-attorney privilege communication, so I cannot disclose a lot about the claim, but currently Deep Advocates is handling an arbitration claim before Cersica, and till this moment, we're almost halfway there. Until this moment, we did not meet even once. We just agreed on the schedule of submissions. We just agreed when we might have an oral hearing if we needed to, and things are going forward without any delay, without any feeling that we're in a crisis or feeling that things are going a bit slow. So this is why actually arbitration is a preferred venue for resolving disputes at this moment. Actually, I believe it's fast, it's efficient, it's accurate, it's way better than courts. I'm not saying that Egyptian courts is not good, but I say it only take a lot of time, and especially after we are going to see the courts opening in June 1st, we will see a huge backlog of claims before the courts, and I believe the decision took recently by Minister of Justice of not allowing judges to go to their judicial vacation might have a very good effect on defying or defeating this backlog.
Thank you, Mohammed, for saying that. I don't think many of the lawyers here agree with you that courts aren't the best way forward. I do agree arbitration could be definitely smoother in some cases, not all, but we'll leave that up for discussion if anyone wants to add anything. And with talking about courts, talking about the GAFI and arbitration, we would like to shift a little bit and go to point D on our agenda, which is government-provided incentives. And I guess many joining us today are interested to know what the current measures in place are with regards to labor law. So we'd like to bring on our colleague Richard Tabishrani. He's the one who's going to be handling this part of our conversation today. So James, we can add him on.
Bringing him in now.
Great. Richard, so I was just saying that a lot of people joining us today are interested in knowing the current measures in place with regards to employment and the labor laws. So we want to ask, are employees entitled to lay off are employers entitled to lay off their employees or even reduce their salaries with the current measures in place, and also taking into consideration Egyptian labor laws?
Sure. In this respect, I had to start with saying that during this troubled time we are currently facing with due to COVID-19, the Egyptian government has taken a number of precautionary measures, including but not limited to the application of all health and safety guidelines, which are set forth by the WHO. Some of the WHO recommendation is to aim to reduce the spread of the coronavirus are, firstly, that employees work from home and to impose a curfew. However, the application of such recommendation has resulted in the economic hardship nationwide, if not globally as well. The effect of the coronavirus and such measures have adversely affected Egypt's labor market, given that many business owners, specifically those in the private sector, in order to mitigate losses, have had to rely on two things. One, reducing the number of the employee and decreasing the salaries. Business owners has to take such measures based on them on the ground of force majeure. This raises an important question, which is, do employers during this difficult time have the right to lay off their employee on such ground, like force majeure, or can this be considered as unwarranted dismissal? This is the question.
That the current circumstance is not considered force majeure and that doesn't allow employers to terminate their labor contracts due to the circumstances that some industries employees can still actually perform their duties. It might not be at full capacity and it might not be completely within their margins won't be the same, but still if you do a system of shifts, for instance, like what they do in factories, you can still actually perform the duty. The current circumstances, however, may be considered exceptional circumstances, and that would grant employers the right to take extraordinary measures with their employees. And it's also like worth noting, in order for employers to be permitted to implement exceptional measures during these circumstances, there are two considerations that we have to think about, namely the measures that would apply on a temporary basis, and that for them not to reduce their employees. So the latter, to be permitted, employers must agree to follow the following things for the employers must follow these for their employees. Reducing their working hours, hence reducing salaries if the employee salaries are based on actual working hours. And another obligation is to oblige maybe employees to use their balance of annual leave, because I'm sure a lot of people do keep their annual leave for a certain amount of time around the year. So you can actually ask your employees to use that for this time to mitigate that loss of work of hours. And also agreeing with the employees to leave without pay for a specific period of time, which is known as furlough, basically. However, such employees reject such offers, and employer then must apply to the competent labor office to obtain approvals for the partial or total closure, layoffs, reductions of the working hours, or the salaries even. So in order basically to, once again, mitigate their losses during this time. I'd also like to note that employers do have the right to demand the application of Articles 1 and 2 of the Law of 156 of the year 2002 regarding the emergency fund, which I mentioned earlier, which helps deal with the total or partial closure or the layoffs of companies. And basically, that being said, employers have the right under any aforementioned circumstances to receive a subsidy due to the interpretation of the payment of the salaries. Once approved by the Labor Office, the fund will pay the employees' salaries on a form of a subsidy, and the fund will be only for this exceptional circumstance, and it can be extended for a maximum of 6 months. This fund, which is once again the subsidy, it just covers 75% of the employee's basic salary. We do have to note, however, that the employer, to have access to this fund, they must have been paying a 1% of the company's profits into this fund annually. And if they don't, it's a lot harder for them to get access to this fund. I'm sorry, the question.
Yes, we have a question from Omar Hisham, which I guess you'll have to answer in absence. I guess the question is that some industries, like aviation, suspended completely. Are they in the same position with regard to force majeure industries that have, I guess, simple commercial difficulties, or is it different? So if the government says you can't fly anymore, does that put you in a different position?
It totally does. And Mohammed, I think you can take this question because you're covering the part on force majeure and hardship.
Okay. So why don't I cover the part related to hardship, and then we can go to the questions, because it will make it a bit more understandable what is force majeure and what is hardship. So as we are all aware, the most common question that got asked since the beginning of this situation, whether this situation can be considered as a hardship, or whether this situation can be considered as a force majeure. So before going through what is the difference between them, I would like to refer to two articles of the Egyptian Civil Code. James, if you please help me with pulling up.
Slide on its way.
Okay.
There we go.
Okay. So yeah, this is Article 147 of the Egyptian Civil Code. The first paragraph refers to the contract makes the law of the party, the constitution of the parties, and cannot be changed unless agreed mutually by both parties. The second one, the one we are referring to, when, however, as a result of exceptional unpredicted events of a general character, the performance of the contractual obligation without becoming impossible becomes excessively onerous in such a way to threaten the debtor with exorbitant trust, the judge may, according to the circumstances, rebalance the contract. The other article I would like to drag your attention to is Article 373 of the Egyptian Civil Code, which says an obligation shall be extinguished if the debtor established that the performance has become impossible due to the reason beyond his control. So after reading these two articles, thank you, James, for the slides. After reading these two articles, the main difference that we can see between them is Article 147 referred to a contractual obligation that is not impossible to perform. However, it is extremely hard and would imply a huge loss for the debtor. And Article 373 refers to a contractual obligation that is actually impossible to perform. So Article 147 is the Egyptian article that refers to the application of hardship, which is an agreement you entered into, and then performing your obligation is not impossible, but it became extremely hard for you, and actually performing your obligation would cost a huge losses for you. The other article is referring to where you actually cannot perform at all the obligation that you have due to this contract. One other thing is that I would like to discuss is whether the force majeure or hardship is implied or is it enforced under the Egyptian jurisdiction. The meaning of implied or enforced is whether do we need to write the article of force majeure or hardship in the agreement, or whether we do not need to write this article in our contracts. So according to the Egyptian law and most of the civil jurisdictions, you actually do not need to write down the article related to force majeure or related to hardship, because they are implied in each and every contract you make, and it will be applied without even writing it in your contract, or without implying it in your contract. Interestingly enough, some other jurisdictions, for example, if you do not type this article in the contract, then you actually do not apply this principle. For example, common law jurisdictions, if you do not write the force majeure, or if you do not write the hardship clause in your contract, then you are intentionally missing or intentionally dropping this legal perspective. Because the whole idea of common law is giving you the freedom to choose what legal principles will be applied and what legal principles won't be applied. So missing adding article for force majeure or for hardship in common law jurisdiction would actually be a huge problem, because this would mean that it's not going to apply, which is to the contrary in the civil law jurisdictions, and especially Egypt.
Mohammed, I'm looking at the questions we're getting on the side.
Yeah.
And people are still a bit concerned that we're talking more on a more broad level versus exactly with regards to the pandemic itself. And they want to know currently all these measures we're talking about, hardship, force majeure, labor contracts, how are they specific to the pandemic right now? And we also received a question with regards to aviation, which, as we know, is on a complete standstill. So is that considered hardship or force majeure? With aviation, I know that obviously tourism taking a large hit, would be considered a force majeure. For instance, a lot of hotels have shut down. If you had reservations, all of that has been canceled. Likewise with your flights, which have been, you were able to reschedule later. But for instance, cargo planes are still functioning very well. And they're the ones, for instance, who are moving a lot of the medical cargo that is being needed. Egypt, when it has shipments coming in from China, or when Egypt actually sends those, it has to do with the facilitation of the aviation community. So yes, there is definitely a part of it. There is no set rule, or are there set rules? Mohammed, can you address this with regards to it being hardship or force majeure specifically with this pandemic?
Actually, whenever I get asked whether this situation is considered force majeure and or is it considered a hardship, usually my answer to this question is actually I don't know. I need to see the contract. I need to see the whole situation to tell you exactly was it a force majeure or a hardship, because as we saw a couple of minutes earlier, there is no set rule to consider one thing as a force majeure or as a hardship. So before answering this question, usually we check the scope of the contract itself, whether it is affected actually by the current situation that we have, or if it is not affected by the situation we have. For example, we're a law firm and we have a lot of retainer agreements with clients that would engage providing legal consultancy and legal advice. So I cannot rely on COVID-19 as a hardship or as a force majeure not to reply to my email. The internet is working, electricity is working, so actually the current situation that we're having does not affect the situation that I have a contractual obligation to fulfill. So like I told you, it depends on the scope of the contract itself. It depends on the what is the obligation the debtor has to perform. Did it actually become extremely hard to him to perform, but still possible? Then we will apply the article related to the hardship, which mainly ends in renegotiating the contract to reach a balance where actually both parties are happy and satisfied to an extent. Or if we didn't reach such an agreement, then unfortunately you will have to go to court to remake this balance. Or if it is impossible to perform the scope of the contract that you have in hand, then definitely it will be a force majeure that will lead to the cancellation of the contract, and will lead to distinguishing the whole obligations arising from this contract. If we are talking about the current businesses that got affected from coronavirus, for example, aviation or so, I still wouldn't say that this can be considered as a force majeure. It is a hardship. They still can perform even if delayed, they still can perform, and they will perform by time. So I cannot say this is force majeure and I'm sorry, my whole contractual obligations are distinguished. It's only an application of hardship, partial closure, and they will be working again. So,
Ahmed, with that being said, we did get a question with regards to contractual obligations and COVID. And the question was, if parties sign an agreement in the present circumstances where they highlighted in the agreement that they are fully aware of the current COVID situation, can any of the parties still use force majeure as an option to exit the contractual agreement? I think this is something that...
yeah. Okay, let me take you back one step back. One of the conditions for the application of hardship or force majeure is not being able to predict the situation that will cause force majeure or will cause hardship. So this is the main condition for the application of these two legal principles. So if you are going to conclude an agreement at this moment that includes a physical obligation, or let's not limit it only to physical obligation, that will include an obligation that will be affected by the current situation. So I cannot see any of the parties claiming after, oh, we have coronavirus, we cannot perform, let's claim hardship or force majeure. Even if they wrote this in their contract, or even if they did not write this in the contract, based on the date that they actually signed the contract in. But I'm reading the question, and actually to be more accurate on my answer. So the question refers to COVID-19, and then the end of the question is referring to, can I use force majeure? Well, of course, you can claim force majeure or you can claim hardship if you sign a contract at this moment, but I wouldn't see it happening, applying for force majeure or hardship based on COVID-19. It might be based on any other circumstances, may God forbid, another act of God, a war, whatever a force majeure event or a hardship event might occur, but I cannot claim due to coronavirus. Like I said, it's the main condition for the application of hardship or for the application of force majeure is the unpredictability. So I cannot claim force majeure or hardship for something that I actually know its circumstances at the current period. So the last thing I would like to mention in respect of force majeure and hardship, like we saw, Article 147 of the Egyptian Civil Code actually put how we are going to solve the situation of hardship. It stated that the judge can rebalance the obligations of the contract, or actually the parties can renegotiate the obligations of the contract. However, when it comes to force majeure, it's only a couple of lines that it said the obligation has to be extinguished. But how we're going to do this in regards of payment, in regards of performance, in regard of the performance that has already been done. So usually I would recommend my clients to always, when they are adding a force majeure clause, to add a consequence of force majeure clause that actually discusses, if the situation of a force majeure happens, then what are we going to do at this time? So yeah, I would like to see if someone.
But there is another. I just want to get to one more question before we do our second poll.
Yeah.
There was one which touches with regards to. Let me grab the question. To tenants.
Yes.
Here by Mr. Walid. Why it could be considered as force majeure when employers, but not its tenants, specifically the owners of activities, are basically are hardly affected by the pandemic. So I think we will touch upon this when it comes to the last section, but Mohammed, if you want to discuss it now, that's totally fine as well with regards to like lease agreements.
Yeah, like we said, the rule or our thumb rule here is it hard or is it impossible? I know the situation for businesses like cafes and gyms, it's getting really ugly, and I know the situation, they haven't been operating for a long time now, and it seems that they won't be operating for another couple of months. So it is a situation that they haven't been able to foresee, and it is a situation that they cannot overcome, but it does not make the performance of the obligation impossible. It makes it hard. So what we usually recommend our clients or that have problems with lease agreements is to renegotiate the terms of the contract with their counterparties to try to reach a win-win situation. Although I don't believe there is a win-win situation, but they should try to reach a situation where each one of them is satisfied and happy only on temporary basis till the situation comes back as usual. So it is an application of hardship in a manner, but like I said, there is nothing called a rule whether lease is a hardship or a force majeure. Things can go, the circumstances of each lease agreement can be completely different from one to the other. So like I said, I wouldn't feel comfortable saying that lease per se will be a hardship or lease per se will be a force majeure. It depends on the situation. It depends on the circumstances of the contract to actually advise whether it's force majeure or hardship.
Okay, so let's take this this next poll, and then we can then move on to more on the recommendations with regards to employment contracts, as well as supply and service agreements.
Okay, while we get the poll loaded, let me just say Richard Kibirani is in the room. So Richard, if you turn your mic and camera, we can be rejoined. Nada, the questions up on.
Yes. So, which is basically the largest issue at hand is how many companies had any of their contracts terminated with because of COVID because of the application of force majeure, and how many had any of their contracts delayed because of hardship. Because if we look at different industries, for instance, I work with our maritime team, which we also got a question about, and our firm is very well known for the maritime sector. And we've seen with the imports and exports that some industries have been extremely hard hit. For instance, we look at the textile industry, which was exporting a lot to Europe, as well as there was a lot of raw materials coming in from China. There is a complete standstill. I personally know clients who their main exporters were the US, the UK, and Germany, and that obviously all those contracts were completely terminated. Versus we could look at the agro business. The agro business, yes, it's not probably at its peak, but the exports are still strong in that area. You see that coming out of the ports of Alexandria, that they are quite, I'm not saying booming, but they are keeping afloat well.
Yeah. Let's see how do we close the survey? Who's had contracts terminated as a result of force majeure, and who's appealed to? We can close that. See. So interestingly, if you can see the results there, Nada, so far more people have appealed to hardship than
So I also feel that we have to think of something as the benefit of Egypt not being completely shut down and having that all our factories are still working, and Egypt really depends on those industries. And we do have a large manpower which is based on a day-by-day salary. So the fact that we're saying it's hardship and not force majeure, yes, it might be tough on the bottom line of most companies, but at the end of the day, we're hopefully not going to see such bad unemployment rates, which we already have, for that to increase because of the shutting down of so much. We also know that a lot of people were asking questions with regards to employment contracts, and is it better to terminate or to reduce salaries because of shifts? We think that people really need to consider a few things before terminating contracts. You need to think about how long the employee has been working for you and if it's economically the right thing, because due to the current labor laws, you would have to compensate your employees if terminating them. And so if you have a company that has 10 people and you want to reduce it to half, you want to get rid of 5, and they've been working at your company for 10 years each, the compensation, Richard has joined us, the compensation will be extremely high. Richard can actually take over that point here with regards to employment contracts. Richard?
Hi, Nada, thank you. And hi, James. And sorry for this internet problem that I faced from my laptop.
So, Richard, we're talking about the employment contracts and what people need to really consider, because that is the biggest problem everyone's facing. There is not much, trade is low, import and export is still working, but also quite low. So production is also low, and they don't need the entire manpower. So what is the action that they should be taking?
Look, basically, this situation cannot be considered as a force majeure that allow the employer to terminate the employment contract of the employees. But rather than, it could be considered as a hardship. So what we used to recommend to employers to do is to enter into negotiation with their employees to reduce the working hours. And also in this will reflect a reduction of their salaries. This is from one point. Another point, there is a subsidies that called emergency fund, which is subject to the Ministry of Manpower. This emergency fund that is made by the Ministry of Manpower that allow companies that face unusual circumstances to go to this fund to cover approximately 75% of the employees' salaries.
Richard, but for instance, if a company hasn't been paying this 1% into the fund, I had covered that part earlier. What can they do? Would they still have access to the fund, or would they not?
Unfortunately, Nada, this would be a very expensive question. You know, this fund has been established by the law number 156 for the year 2002. Okay? So if the company hasn't paid the previous year, retroactively the previous years, the 1%, she must pay again the membership, this 1%, from the day of incorporating the company, or from the day where the law entered into force.
So if your company was established in 2001, you would only have to start in 2002, because that's when the law was put in place. Okay.
Yes.
Great. And we have a question here of Ishan, who says, so it must be mutual consent from the employer and the employee, not the sole decision of the employer. I think he's asking for clarification on that, Richard.
With regards to termination of the employee by the employer. As I was saying earlier, and Richard could back me up with that, there is an issue with regards to labor laws here and compensation when you let go of people. So Richard,
the compensation, in case that the employer terminates the employee contract, he had to pay the compensation of 2 months of salary of every year of service for this employee. If he terminates it, this is the compensation, and also the courts stick to this rule.
Yes, the courts are very much pro the employee.
Take the side of the employees.
Yeah, and we also have to take note that should a business be downsizing, for instance, because of the current situation, which is we don't know when it's going to continue probably till like September, and with this manpower, if it's a skilled manpower, is it worth firing someone, paying the compensation, and then coming back to rehire someone again in a couple of months? So that is more of a business decision from the company's point of view, if it's worth it. financially to do that, or if it's better to negotiate with the employee to maybe reduce the salary, like we said, take those days off as much as possible, or even try and figure out a way that they can compensate the employees maybe later on, once obviously the influx of work and cash flow is back to normal.
Okay, so just to clarify, so decision involving the reduction of wages and the obligation of the employee to take unpaid leave, is that around mutual consent between the employer and the employee, or is it simply the employer can decide to reduce wages and put people to make them unpaid?
Look, James, it must be through negotiation between the employer and the employee.
Okay, it's consensual. Okay, excellent. Thank you.
If the employer does decide to do this, and an employee creates an issue for him, it will create a bit of a headache for the employer. But we understand that now, with a lot of factories, that is being put in place. A lot of employers are giving their factory workers half the time as well as half the salary.
Okay.
So those were the points that were. If there are any other questions, we'd want to move to the final part of our discussion, which is the digitization and working from home, because we've had a few questions with regards to e-contracts, e-signatures, and basically online platforms. Mohammed previously touched on that when it came to board meetings and such, and how those can now be done through web and video. And we'll move now to see the other questions we got, which one of them was, would Corona dictate future business models, and how would digital transformation affect the way business is done in Egypt?
Okay, so before I answer this, I would like to drag your attention that in 2005, the Egyptian jurisdiction executed or issued a law regarding the electronic signature. This law, it is claimed to be not executed properly here in Egypt. It's a bit, the application of this law necessitated a lot of technology that I believe back in 2005 we did not have this kind of technology, but we're starting to have it now. So the matter of the digitization of the services rendered by the Egyptian government is not something new, or it is not a new thought that came to the government now. However, I would say that the current situation actually boosted the need to digitize all the services and digitize all what is actually happening. For instance, we can see schools are starting to provide lectures online. We're starting to see schools having their exams online. We're starting to see the web portal of the Ministry of Interior having a lot of online services that you can actually use, whether related to the civil register, issuing birth certificate, the certificate, all these kind of documents. We have also seen on the other side, renewing your license, paying your fine, actually, and even opposing before the public prosecutor from your own home, from your computer. When it comes to proving electronic signature or using electronic signature before courts, I would say that this principle had been applied probably a couple of years ago. Personally, I had an employment claim, a labor claim, that actually we used the emails that were sent from the employee to prove his malpractice. It was a bit hard in the beginning to convince the court that emails have a power of proof. It was hard to have the court responding positively on our request. However, we actually did it, and we got an expert from the NTRE, the National Telecommunication Regulative Authority. We had him visiting the premises of our clients. We had him inspecting the servers. We had him seeing that everything is not manipulated. And fortunately, he decided in his report that actually these emails were sent from the laptop of this employee, and thank God the claim ended in our client's favor. So proving emails is not something related to 2020 only, but it's something had been long understood, but not strongly claimed, I would say, because after all, we are the motive, we are the moving power that shall make the courts go from the paper to emails and other electronic communication. Like I'm saying, I'm liking how the Egyptian government is currently treating the situation we are facing. I have seen the digitization of almost all the services that are rendered by the government, which actually makes it easier for all the users to use these services. It makes it more safer. It makes it more friendly to renew your license or just issue a birth certificate. I would say in the coming not years, I would say in the coming months we will see a lot of more decisions or more regulations related to the digitization of the services rendered by the government. We have seen back in August 2019, the Economic Court had its rule related to the electronic filing of claims and the electronic investigation. Yeah.
So that gives me, that leads us to another question we had received previously, which was how can legal services develop and transform to meet the ongoing expected digital transformation? So court filings legally, as well as having emails being officially accepted through courts. What else? What other legal developments and services do you think would assist? Because something like, we're hoping nothing like COVID happens again, but our legal infrastructure currently is very people contact to contact based. So what other measures that could be in the pipeline or are in the pipeline, other than the banking industry, which is online legally, that we think would be
like I'm telling you now that we're seeing the economic court trying to work electronically. I believe in the coming couple of months we will see the courts, regular courts, working electronically. Maybe we will see some other services that are rendered by the government given electronically or provided electronically. So there are a lot of perspective and a lot of things that we can think of that can be transformed into electronic system. On the commercial side, I would say people are starting to be more understanding of electronic signature and circulating documents, and to the fact that you do not have to meet to sign a contract, you do not have to meet to take a decision, you do not have to meet to run your own business. All you need is just some internet connection and a laptop, and basically you will be able to do whatever you need to do. The good thing here in Egypt, the good thing here in Egypt, we're starting to see businesses asking more about electronic signature, businesses asking more about the power of proof before the courts. So as I was saying, despite COVID-19 made us all suffer and made us all not pretty much happy with what is going on. However, on the business side, it broadened the minds of people running the business, and it gave them new ideas, new issues, new things to work on, and especially the principle of working from home and the principle of facilitating or providing utilities and facilitate to employees to work from home.
Mohammed, what you're saying is very interesting, and I know that a lot of the large working from home, saying that, and digitization allowing people to work remotely, working from home. A lot of large law firms now abroad are reconsidering the amount they're paying in real estate, and are they thinking, should we have less real estate and actually just work from home on a shift basis? Do you think that that will follow in Egypt, or do we need a lot more time for that to actually be implemented?
Well, again, I wouldn't see this happening in Egypt anytime soon. Still, we are under the impression that someone will not work unless he's in the office, which actually I've been talking with a couple of my friends from the HR department, and they were developing a method on how to monitor the performance of their employees while working from home. I've seen even on different webinars that actually HR is providing chairs to their employees to make it more easier for them to work from home and to be more productive. So I'm getting the impression that business owners are seeing it more I wouldn't say efficient, but more easier to allow employees to work from home only on the condition that these employees are performing properly, and on the condition that they business owners develop one way or another to monitor how the employees are working and to monitor how business is going.
This is a perfect shift in what I wanted to say next, which is some industries, yes, you can work from home, while others, obviously, which are very laborsome, you cannot work from home. And one of the questions we had was regards to the digitization of a particular industry, or the registration of things with regards to real estate and mortgages. So with real estate, currently everything has to be done face-to-face and papers. And the issue, I think, and Richard can touch on this if he can hear us, I'm not sure if he can or not, with regards to registration of real estate. I do think that could be done digitally, or it won't be done digitally.
Unfortunately, the registration of real estate and lands are subject to the Notary Public and Land and Real Estate Registration Office. This office must always require the physical attendance of the applicant, where the applicant must sign before the notary, and this is from one side. And another side, several surveys are performed on the real estate of the land from the department itself. So unfortunately, until today, it had to go through, it cannot be digitized.
Yes. So once again, even though some industries, parts of it, I think, can become digital, other parts of it will be a lot harder for us to do. So those were some of the questions. We're currently answering a few more. Omar had just sent something with regards to the GAFI, the e-signature. So Richard, can you address that actually? Mr. Omar is saying that regarding the e-signature, we know that GAFI tried to implement it, but in your personal experience, is it really effective in Egypt, or do we still need time for improvements?
Look, the e-signature...
Go ahead.
Okay, thank you. Look, the e-signature is working with the GAFI before, at the time of the incorporation of any new company, where you go through you prepare the article of association, and through the website of the GAFI, you prepare all the articles, and you take all the approval and all the formal process through the web. But at a later stage, the founders themselves or their attorney must appear before the GAFI just to sign on the articles and the contracts, and also will stick they must appear before the notary because of the same process like the registry. The applicant must appear in person before the notary, because the article of association must be notarized by the notary public.
Okay, and staying on the topic of digitization, We had a few questions which regarding fintech, which is the financial tech, and we know that Egypt is pushing forward in that in many ways. We've seen it with things like wallets and online banking, but that's not particularly it because you also need a lot of AI. That is not a specialty that I'm aware of, but I know that online payments and the digitization and the having more of a cashless society is something that the government is pushing for. In my particular field with regard to, for instance, shipping, any dues or and such have to now be paid electronically or through bank transfers to avoid middlemen, as well as to avoid the movement of cash and more of account-to-account transfers. So I don't think that's really considered fintech, but it's a tech update in financial sector of an industry. And the other questions we had was regarding to video conferences, which we've touched on. If anyone else has any more questions, we'd be very happy to answer them. And if there's anything that needs clarification, please send them our way. We have a couple more minutes to talk to you guys.
Well, shall we cut to the final poll? How many companies are willing to spend more time on facilitating working from home? Should we?
Yes, please.
Yeah.
Guy, can you click the final poll? Yeah, it's completely. We won't reveal your identity. We're interested to see what's going on in the state of the. So I think second will be on the final poll. I should say, well, we're having a problem with that, so we'll have to leave it. Apologies. Nada, Mohammed, Richard, if anyone has a follow-up question, may they contact you?
Yes, please.
Yeah, sure.
Yes.
Pleasure.
I can, if you would like to circulate our emails, or I could put it in our chat right now. Either one is completely fine. Again, we understand that COVID is not something anyone predicted for, and obviously we're going to have to change our lifestyle and our business ethic. But on the plus side, it has pushed certain industries in the right direction in Egypt, especially our court system. And we're hoping that this keeps going forward across the board.
Excellent, great. Well, look, we will have a recording of this webinar available on our website shortly. If anyone would like a copy, please feel free to email, but it'll be up there on the Legal 500 website. Look, thank you very much to advocates for a fantastic presentation. Thanks to Nada El-Deeb. Thanks to.
Thank you.
Thank
you, sir. Thank you.
Thanks for everyone for sharing.